can choose which language they use in front of the court. So they can speak Ladino, German, or Italian. People in France were both Austrian, so German was their native language. They are brought in front of the court, they start speaking German, and then they ask to shut up because the interpreter hasn't arrived yet, and the judge will listen to the case in Italian. They were wondering why, and they were told that only Italian citizens who reside in the province have the right to use German language with the authorities. And the general rule in Italy is that all the foreigners are only entitled to have the process in the state language of Italy, which is Italian. And although the judge is perfectly bilingual and understands German very well, both German and Italian, as all the judges in the north of Italy, the case, which involves two Austrian citizens who are native speakers of German, will be proceeding only in Italian. And everything will be translated. So those guys were wondering whether their rights were infringed on the basis of their rights to non-discrimination on the basis of nationality were infringed in this case. Because obviously they compared themselves with Italians in the same province who are free to use any of the three languages they want in front of the court. And again, the question arose whether they actually, within the scope of community law, and the court said that they're citizens of the community, that they find themselves in different member states, and that's why they should be compared with the citizens of that state in a similar situation. And obviously the Italian government said, look, in the whole of Italy, Italian is the only language. So let's compare them with Italians in Italy, for example. Italians in Sicily, for example. Italians in Sicily only use Italian. So if we compare Italian nationals in front of the court with people in France in front of the court, then basically there is no problem. There is no violation of the non-discrimination right. And the court said that no matter what the general rule is that applies to the country, all the specific provisions for minority protection that apply even within a specific region should also be made available to the citizens of other member states. Because otherwise we have discrimination on the basis of nationality. Because discrimination on the basis of nationality, non-discrimination on the basis of nationality means absolute equality between citizens from, let's say, between the nationals from different member states who come within the scope of community law. And so in this case, in the end, the Court of Justice said that not to hear the case in German would result in a breach of community law. So basically the case was heard in German in the end, not in Italian. And there are plenty of examples. But now the European Court of Justice, having these two principles, the principle of services and citizenship apply, is hesitating between the two in a way, because the case line, which I also advise you, is not a consistent one. The court decides 2 or 3 cases based on citizenship, and then the case based on services pops up. And it's extremely difficult to understand why it is done. Probably by using services, the court is simply sending a signal to the member states that their fears of the general equality principle, which would be connected with the status of citizenship of the European Union, is not the direction that the court is taking. Because obviously when we speak about services, then the general equality principles based on citizenship is something that doesn't concern us at all. So the court is very cautious because the member states are very afraid. And now we find ourselves in a very interesting point of development of community law. Because it's not clear how the court will actually proceed. And because the obvious need at this point in order to protect the citizens is to have a citizenship of equals that will guarantee the application of non-discrimination in all the cases. That will guarantee general application of this principle to all the citizens by virtue of their possession of this status. But at the same time, the member states are too afraid to permit it. Yes?
I don't think I understood the example of German Austrians speaking German to the Italian court. Do you mean they were speaking without translator after the decision of the...
No, after the decision of the ECJ, they were given the right to have their case heard in German.
Without
not in Italian, without any translation, because
does it mean that if Maltese citizen does a crime in Slovenia, the Slovenian court should hear him in Maltese language?
No, because here it went about the regional languages. German is an official regional language in Trentino. So.
It was a particular case.
It was a particular region.
Yeah.
And that's the interesting point in the case, that the Italian government was claiming that non-discrimination does not mean equal treatment between those Italians who get special minority rights, like the right to use German, and non-discrimination and community citizens coming from German-speaking countries, because the general rule, of course, is that the language of the state is Italian, so we cannot speak, according to the Italian government, about non-discrimination and discrimination if we disallow foreigners or community citizens from other member states from using special rules which Italy designed especially in order to meet the needs of a particular minority in the north of Italy. And the Court of Justice said, no, you cannot put any limitations on the scope of the non-discrimination right. So this is one of the leading cases in minority protection in community law, because there is no principle of ethnic minority protection as such in the community.